All right, so good morning, everyone, once again. My name is Arudi Laura, Program Officer with the Network of African National Human Rights Institutions. I wish to officially welcome each and every single one of you to this webinar, which mainly looks at the role of national human rights institutions as well as the civil society organization and non-governmental organization in the protection of vulnerable and marginalized communities in Africa. So this meeting has been planned for by not only NANHRI, but the Southern Africa Litigation Center, which primarily works with regard to democratic governance, the rule of law, and access to justice through strategic litigation amongst other legal avenues in order to ensure that social justice is achieved for all, and especially vulnerable and marginalized communities and persons. So without further ado, we want to skip right into the program, whereby I'm going to give you an overall on the key objectives. So one of the key things that we know about the African continent and around marginalized and vulnerable groups is that there's a lot of disproportionate discrimination, stigma, and violence that they face. And as well, their human rights are rarely realized to them. This is, of course, because of, the stringent laws in other areas, the social cultural attitudes that sometimes limit the realization of these rights, as well as the lack of understanding of their rights amongst the population itself. So when we are talking about vulnerable and marginalized populations, we are here talking about persons who use drugs. We are talking about LGBTIQ persons or SOGI-esque persons. We are talking about sex workers who usually face a lot of criminalization or arrests due to as I said, the stringent laws and all that. So the key objectives of this webinar is to enhance not only the national human rights understanding of how they can best protect and realize the rights of these persons, but as well is to enhance the understanding of everyone who is within us or who's come to be able to amplify their voice and advocacy initiatives in order to ensure that the vulnerable and marginalized populations are protected. Some of the outcomes that we expect from here, looking at the agenda, is first, of course, we hope that through this, the role of national human rights institutions will be enhanced amongst all the delegates present. We hope to also have a good exchange of the best practices or of the lived realities of these vulnerable and marginalized groups, with a specific focus on Malawi. We also, as most of these impediments are brought about by, the legal constraints, we do hope that we can also have an understanding of some of the court's pronunciations on matters equality and non-discrimination within our domestic courts in Africa. So that is overall the objectives and the introduction of this meeting and forum. I can see already a hand. No, it's been put down. But as well as we start off the meeting, I would kindly ask the delegates present through using your chat box to just give us a brief of your name, the institution that you represent, and maybe the role that you play. This is to also assist us know the range that we have reached with this. So without further ado, I would want to welcome the chair of the Malawi Human Rights Commission, Madam Chikozi, to come and give her welcoming remarks to officially open the webinar thereafter. So, Commissioner Chikondi, the floor is yours. Thank you.
Thank you so much, Arudi, for the introduction. And also thank you for co-hosting this webinar together with the Southern Africa Litigation Center. I always find myself in a situation where I'm wearing two hats. As introduced, I chair the Malawi Human Rights Commission, but I also lead the criminal justice program at the Southern Africa Litigation Center. It's such a great honor to have all of you for this webinar. I'm always excited when we meet together as advocates and people that advance human rights in our various capacities to talk about vulnerable and marginalized groups. In this particular context, we are looking at LGBTIQ persons and also sex workers. When we were planning this webinar, we were looking at various groups of marginalized persons that we work with in various capacities in our respective institutions, and the progresses that have been made at national, regional, and international level in protecting these communities. And sometimes when we're working, we're not familiar maybe with the progress and how much we can learn from each other in terms of improving the rights of the vulnerable groups. So it's such a wonderful time that we're here to talk to each other, to share experiences, and see how based as national human rights institutions, we can advance the agenda of human rights within our respective mandates in our respective jurisdictions, but also being cognizant of the fact that there are so many groups of people that are excluded in as much as human rights are universal, but so many other groups that are not able to claim or protect their rights because of various barriers. And that's what we're here for, to talk about that and to see how we can make progress, because human rights is for everyone. And if we have certain sectors of society that are excluded as human rights institutions, we have a duty to protect each and every human being. And I'm happy that we have the experts that are here that are going to lead the discussion, and I'm looking forward to your full participation. I think looking at the guide that the NANHRI has developed for the national human rights institutions in Malawi on implementation of Resolution 275. When you look at that guide, you would think, oh, by now we should all know what we should do around these issues. But I think the learning process keeps never ends. I think for us is to say, from what we already have, how do we improve access to justice, as well as protection of rights of all vulnerable groups that we're working with. Otherwise, thank you so much. I hope you're going to enjoy the webinar. Ask as many questions, contribute as much as you can, and I look forward to our discussion. Thank you so much, Aludi. Over.
Thank you very much for that overview, and thank you for opening for us the session, and as well as bringing about, the reason why that this meeting or this short webinar is important, as well as bringing about some of the resources that have already been put out in order to assist in this work. Luckily, as well as per the agenda, you're also our first expert to come and do a short presentation, which is a presentation that is on the recognition of human rights of key populations in Africa. Those are the groups that you have already alluded to. What are some of the barriers, when we talk about vulnerable and marginalized group? What are some of the barriers that distort their realization or impede their realization of human rights? What are some of these international and regional frameworks that as human rights advocates across the African continent, we can be able to utilize in order to ensure the extension and the protection of their rights, as well as, maybe a Malawi experience. What is the Malawian experience? What are some of the challenges and maybe some of the best practices that you have come to adopt to, assist within the process of ensuring that all persons, regardless of any of their status, that is race, gender, sexual orientation, amongst others, are protected within the Malawi. So I'll still, once again, give the floor to Commissioner Chikondi to give us a short presentation on the first panel. As well, just before I hand over, we have been able to enable the chat for you to put out your name, the institutions that you work for, and maybe your role, as well as the chat is also open in case there's any other question, any other best practices that you'd want to share as the webinar goes on. Please feel free to just put it in there, and the team at hand will ensure that all views are considered and heard. So thank you very much. Without further ado, Commissioner Chikondi, back to you.
Thank you so much, Alod, once again. I'm going to kickstart our discussion with a topic on recognition of the human rights of some key populations in Africa, with focus on LGBTIQ and sex workers. I think the first question that comes to many people's minds when we talk about LGBTIQ is why should we care? Why should we talk about LGBTIQ persons? Why should we talk about sex workers? And I'll be happy just to also hear in the comments, like, how do you feel when you hear this topic? Genuinely, how does it make you feel? And I think looking from how society perceives issues of LGBTIQ, sex workers, you can see that a lot of people frown at the mention of why should we protect sex workers? Why should we protect LGBTI persons? Because there's a thin line in understanding that LGBTIQ persons are human beings, and they're not, their identity is not their sexuality. They are human beings, they are mothers, they are children, they are fathers, they are aunties, they are uncles, they are sisters. They are just people like you and me. And so when we talk about protection of LGBTIQ, we're talking about protection of human rights. That's what we're talking about. It's not a new phenomenon or anything strange. We're talking about human rights because lesbians, gays, bisexuals, intersex are human beings. And now when we look at the international legal framework, when you look at the Universal Declaration of Human Rights, the International Covenant on Economic, Social, and Cultural Rights, the International Covenant on Civil and Political Rights, in all these international instruments, their Article 2 provisions provide for non-discrimination. And part of the grounds for non-discrimination, from all that's listed there is other status. And we've seen that the non-discrimination on other status has received a wide interpretation at international level, at regional level, even in some countries at domestic level. So you'll see that the phrase other status is not the categories of discrimination that are provided in the international legal frameworks are not exhaustive. They should not be limited to items that are listed in the provisions. So when you look at how international mechanisms and regional mechanisms have interpreted other status, the emphasis has been on issues of universality of human rights and non-discrimination. I'll give you an example of a case of 1992. This one is a case of Tutin versus Australia, where the Human Rights Council held that the use of sex as a ground for non-discrimination by the International Covenant on Civil and Political Rights also extends to sexual orientation, such that laws that discriminate based on sexual orientation or private consensual same-sex acts were found to contravene the treaty. And it was also the same wording of the court in the case of Young versus Australia in 1999. And there's also been general comments that have come from the human rights mechanisms. For example, general comment number 20 by the Committee on Economic, Social and Cultural Rights, which also explicitly stated that the term other status for non-discrimination is also applicable to sexual orientation. And I think this is something that we struggled with for those that are practitioners that have litigated on this issue, especially related to LGBTIQ persons. There has been some jurisdictions where they have limited the interpretation to say if it's not explicitly stated, it's not provided for. But the generous interpretation has been that it's non-exhaustive. It can be on anything, including sexual orientation. And apart from the court cases and case law that has developed, there have also been resolutions that have been passed, which relate to protection of persons based on their sexual orientation and gender identity. We have a resolution that was passed in 2011, another one in 2014 by the Human Rights Council, all that aim at protecting LGBTI persons and extend the definition of other status to include discrimination based on sexual orientation. Also, there's an independent expert on sexual orientation and gender identity that also assesses the implementation of existing international human rights to overcome violence. I think it's well known that LGBTI persons, even sex workers, do face form of discrimination and violence. And the independent expert on sexual orientation and gender identity is there to raise awareness on violence and discrimination against persons on sexual orientation, work in cooperation with states, including NHIs like ourselves, and also address some of the multiple intersectional and aggravated forms of violence that persons face because of their sexual orientation or gender identity. Apart from that, even during the peer review under the Universal Periodic Review, we have also seen issues of LGBTIQ being raised by states to their peers. For example, in 2012, the UPR of Ghana, it was advised that the provisions in the Ghanaian constitution that guaranteed equality and dignity should be equally applied to LGBTI persons. Even Malawi in 2015, it also accepted recommendations to take measures to protect LGBTI persons from violence and also prosecute perpetrators of such violence. In 2018, Burundi was also urged to take necessary measures to decriminalize same-sex relationships, and the same with Burkina Faso and Nigeria. In terms of soft laws, we've seen the Yogyakarta principles that have been widely recognized as principles that apply in protection of human rights, especially on issues of sexual orientation and gender identity. When you look at the preamble of the Yogyakarta principles, it recognizes that international human, all persons, regardless of their sexual orientation, are entitled to free enjoyment of human rights. And there's also been additional principles that were developed in 2017, which are called Yogyakarta Principles +10, YP +10, which also has other 10 principles And one that I can highlight is the right to freedom from discrimination and sanctions on the basis of sexual orientation, gender identity, gender expression, or sex characteristics. Now, within the African system as well, we have a system for protection of LGBTI persons within the African Charter itself. I love the preamble of the African Charter because it focuses on the entitlements. The rights come in as entitlements in the African Charter, because when you look at the preamble, it talks about freedom, equality, justice, dignity as essential objectives for achievement of legitimate aspirations of the African people. So any human being is entitled to freedoms, equality, justice, and dignity. And in terms of the clause on non-discrimination, it's also similar to those that are at international level, where it also provides for non-discrimination on so many others that are expressly provided, including other status. And the same with the international mechanisms. Within the African mechanism, the African Commission has also expressed the view that the other status in the African Charter includes grounds other than those that are stated in the text of the African Charter. And there have been cases that have been before the African Commission, like the Zimbabwe Human Rights NGO Forum versus Zimbabwe case, where the Commission stated that the aim of Article 2 of the African Charter is to ensure equality of treatment of individuals, irrespective of nationality, and all others, including sexual orientation. Apart from the jurisprudence coming from the African Commission, there's also been the Resolution 275 of the African Commission, with which resolution was passed in 2014. And this has been a groundbreaking resolution because it was the first official affirmation of the rights of LGBTI persons in Africa by the African Commission. So essentially, Resolution 275 calls on states to ensure that human rights defenders that are working in an enabling environment that is free from stigma, reprisals, or persecution due to their human rights protection or activities, including rights of minorities. The Resolution 275 further requires states to end acts of violence and abuse by state or non-state actors by enacting effective and implementing laws that prohibit and punish violence against people based on their real or imputed sexual orientation or gender identities. Now, with all this framework, the international framework, the regional framework, how much progress have we made? When you look at Angola, Angola enacted a law prohibiting discrimination on the basis of sexual orientation and gender identity. Some other countries like Botswana, Gabon, Mauritius, Mozambique, Seychelles, they all repealed laws criminalizing consensual same-sex relations between adults. And also Mauritius has also included sexual orientation as a prohibited ground for discrimination in employment. And just last year, the African Commission also adopted Resolution 552, which has affirmed the rights of intersex persons on the continent, calling for countries to prohibit a range of human rights violations against intersex persons, including violence and forced surgeries and discrimination. So we have made progress, I think, after the adoption of Resolution 275. Further progress we have also seen in the African Commission itself. For example, in 2017, the Commission adopted a Resolution 376, on the situation of human rights defenders in Africa, which explicitly recognizes both the added vulnerability and the need for specific legislation to protect LGBTI persons and human rights defenders. The same progress has also been seen with the Committee on the Prevention of Torture in Africa. In General Comment number 4, they also recognizes that the right to redress for victims of torture and other cruel, inhuman, and degrading treatment or punishment. They list sexual orientation and gender identity as one of the grounds for non-discrimination for victims to seek redress. There's also the 2015 guidelines on conditions of arrest, police custody, and pretrial detention, commonly known as the Rwanda guidelines. You see that guideline number 30A also recognizes that certain measures that are put into place to protect persons based on their gender identity should not be considered as discriminatory. And also in 2017, guidelines on freedom of association and assembly in Africa also recognizes that the basis on one can be discriminated against includes sexual orientation or gender identity. So we can see there's a lot of progress. I'll actually encourage you to read the guide that NANHRI did for NHIs, because all what I'm telling you, it's right in that document. And there's a lot that we can see in terms of progress that has been happening since the adoption of Resolution 275, and also how these human rights mechanisms have expanded the protection of human rights, even though the core human rights treaties have not expressly provided for sexual orientation, but the interpretation and understanding and processes that have been developed subsequently have opened up to recognize expressly protection of LGBTI persons. Yes, we've made great progress, but there's also been setbacks. We've seen like several countries that have pushed to enact even more punitive laws and policies and practices against LGBTI persons. A good example is Uganda. We are all aware of Uganda, that it had enacted the Anti-Homosexuality Act in 2023 that actually enhances the punishment in some of the offenses for serial offenders to death penalty. And also, I think we saw in Kenya, a member of parliament had introduced a bill which prohibits consensual same-sex conduct, same-sex marriages and related activities. And also, the African Commission itself has also not been 100% on the side of protection of LGBTI persons. We have seen that they rejected the observer status applications of 3 NGOs that were working on the rights of LGBTI persons, despite the values that they had advanced in Resolution 275. Now, let me zero it into Malawi. I think what's happening at the international or regional level, it's not different from Malawi. I think for Malawi, the first time that Malawi had to face the issue of LGBTIQ at a national level was in 2009, when there was a case that a trans woman publicly got engaged to a man. And that sparked debate in Malawi. And of course, the 2 men were convicted, sentenced to imprisonment for 14 years. Of course, they were later pardoned by the president. But despite the adoption of Resolution 275 in Malawi, the legal framework in Malawi still criminalizes LGBTI persons, and nothing has changed. There's been reported cases of violence against persons, LGBTI persons, even activists and community members that have faced harassment and arbitrary arrest. I myself have been a victim of the same, where I was kicked out of my church for representing my clients who are an LGBTI organization that are fighting for registration. So sometimes the fight can be very personal for standing up for those that are marginalized. And also there's been reports of police not paying a blind eye basically to issues of abuse of violence against LGBTI persons. And there's also been like mixed signals from government. For example, there was the moratorium on arrest for same-sex conduct. And then later on, we saw that the moratorium was suspended by the court. And also the government has been receiving a lot of pressure, domestically, international, to decriminalize same-sex relationships. But the political situation, as in many other countries, remains the same. Even before the adoption of Resolution 275 in 2012, the then President Joyce Banda committed to repeal the same-sex laws. But 3 days after that commitment, we saw the Attorney General ordering that the police, and of course the Attorney General had ordered that the police should stop arresting LGBTI persons, but then later on he retracted his statement after 3 days. Also, like I said, the moratorium was in 2014. And although there was the moratorium, but in 2015, there were men that were arrested and charged under the sodomy laws, and police kept on arresting people. In 2016, the moratorium was suspended by the court, and then one of the organizations that work in Malawi in protecting rights of LGBTI persons, SEDEP, reported 15 cases of stigma and harassment and violence of LGBTI persons after the moratorium was suspended. And we also saw in 2018, the Human Rights Watch also released a report of violence showing that LGBTI persons in Malawi, they face routine violence and discrimination. And just recently in June, on 28th June this year, the High Court, sitting as a constitutional court, refused to declare the sodomy laws unconstitutional. The court found that the laws are constitutional, and that if there's need for any reform to the law, that should be left to Parliament. So those are the lived situations of LGBTI persons in Malawi, and that's where we are. Of course, we cannot say all is bad. There have been some strides, and we have like a growing strong activism from civil society in Malawi that promote LGBTIQ rights. Also, we saw that the Malawi National Strategy Plan for HIV and AIDS for the period of 2020 to 2025, it includes the transgender and men who have sex with men as part of key populations to be targeted to reach the goals of the National Strategy Plan for HIV/AIDS. And also in 2021, Malawi had the first Pride Parade, which was also a milestone for Malawi and there were not serious reported cases of violence. There were much peaceful, and I also participated in that. So I can vividly remember that it was quite a peaceful process. So there has been strides, to be honest, but I think the issues of stigma, violence do remain for LGBTI persons. Just 2 minutes to speak on sex workers in terms of Malawi. I think we've also seen progress from moving from complete discrimination to where we've seen sex workers that have formed alliances, organizations that they stand and fight for their own rights. In 2016, there was a case in court where the sex workers challenged the offense of living on earnings of prostitution. And the court held that the offense of living on earnings of prostitution does not target the sex worker herself, but it targets the people that live off that sex workers. That actually the offense of living on earnings of prostitution is there to protect the sex worker, not to criminalize the sex worker. So it was quite a huge milestone because many sex workers in Malawi were being arrested under that particular offense. So it's been a journey of a mixed bag, great strides, and also going back. And I think as NHRIs, what are we doing? What is the Malawi Human Rights Commission doing? And I must say that there's been a lot of progress in terms of protecting human rights of LGBTIQ persons. The Commission has been engaging the community, engaging with community leaders, police officers, and also creating a platform where the LGBTIQ persons can report issues of violence or any other experience that they have been going through to the Malawi Human Rights Commission, so that we compile those to form a basis of engagement, because we understand that we have a duty as a commission to protect every right and everyone's rights, and that includes the rights of LGBTIQ persons. So yeah, that's what I can say, Aludi, for Malawi. Thank you so much.
All right. Thank you so much for that presentation. I loved how you went around it, covering not just the binding instruments or treaties that most of our countries have, ratified, but as well touching base, especially African instruments and African soft laws that have been adopted to ensure that there's protection of vulnerable groups across the continent. As well as you were speaking amidst the discussions and the pointers that you've given, I remembered that one of the key soft laws as well within the African continent is the decision by the African Court that came about in December 2020, which also speaks on vagrancy laws and gives the states a duty and an obligation to repeal or decriminalize petty offenses. And when you look at vulnerable and marginalized populations, vagrancy laws are some of the areas, actually one of the biggest legal hurdles that they have to cross or they have to face as they fight for their rights or as they fight for the space to be and to exist within society. So in brief, as we proceed to the next session, I want each and every one of us to take away from this discussion that there's a lot of instruments within the African continent and within the religion that have been specifically and explicitly put out to protect key populations, vulnerable population, marginalized population, or diverse populations as a whole. And therefore, it's important for us to be aware of these human rights frameworks and as well utilize them in the best way possible. And I believe as we go on with the conversation, we shall get a few bits here and there on how we can be able to engage with these frameworks. So thank you so much, Commissioner Chikondi, for that very good analysis, and as well not just bringing the Malawi experience, but as well exploring some of the advances that have been made across the African continent, and as well the challenges for us to ponder upon. And as we move on to the next presentation, which basically, as I introduce that session, due to all these challenges that vulnerable and marginalized people face, one of the key strategies has been towards judicial justice, approaching the courts to be able to give either an interpretation or a decision on a certain matter or a certain provision within the law. And therefore, there's been, a lot of us trying to go to the courts within our different countries to see whether they can be able to provide a better clarity on how to interpret some of these provisions. And with this presentation, there's no other better person to give it to us but Tambo Buthelezi. I hope I've done that justice, but you can give us, the best pronunciation. But Tambo from the South African Litigation Center, which primarily works on this, is going to take it ahead and share their views on it. So welcome, Tambo. The floor is yours.
Thank you, Arudi. Like Arudi said, my name is Tambo Buthelezi. I am the social justice researcher for SALC. And just to note, I'm gonna try and keep it short. For the sake of brevity, it's Friday and it's November, so end of year fatigue. Most of the cases that I will be speaking on, and we shared this in the beginning of the webinar, we'll share it again, are on the case compendium that SALC and its partners compiled. So if you want to check it out, please do so, and I hope it's very useful. Plus, it's free. And to get into the crux of the issue, in many of the cases that we have come across, especially within the continent, the right to equality has been closely linked to the right to dignity. And where courts have also noted that where the right to equality has been breached, this is also a violation of the right to dignity. And the best starting point would be in Botswana, in the case of Attorney General versus Mutidi. So I won't get into the facts, just the tidbits that I think would be useful for this discussion. If you want to know more, again, case compendium. But in this case, the court noted the importance of equality, dignity, and liberty, and how these reflect the values of pluralism, tolerance, and inclusivity, which are the backbone of the discussion that we are having. So the court went on to further note that minorities who are perceived by the majority as deviant or outcasts are not to be excluded or ostracized. And the court then noted that discrimination has no place in the world and that everyone, all human beings, are born equal. And in the same vein, in another case from Botswana of Ramoge versus the Attorney General, the court noted that fundamental freedoms are to be enjoyed by every member of every class of society, whether rich or poor, whether citizen or non-citizen, whether it is prisoners or sex workers or otherwise people who are deemed to be social outcasts. Everyone has the right to the protection of their fundamental freedoms. In Kenya, in Non-Governmental Organizations Coordination Board, the court noted that the Bill of Rights was not only there to protect people that we might find likable or acceptable, but it protects also people who we might find morally objectionable or reprehensible. And Chikondi mentioned this case of Pepo Banda in Malawi, where during sweeping exercises, a few women were arrested, some of them who were sex workers, and the court noted that the law was there to protect them and that their arrests were a violation of their fundamental rights. And this is just another example of how courts have protected marginalized communities. And in protecting certain members of society, such as LGBTI persons or sex workers, the right to equality and non-discrimination has been used during arguments and by the courts themselves to protect individual rights. One case comes to mind from Zimbabwe, Nathanson versus Mteliso, where the court noted that that transgender citizens are part of Zimbabwean society. Now, in this case, sort of give you a brief background. In this case, a transgender woman was arrested for using a public restroom that was labeled women. She was extorted for money, abused by the police, and the court then said their rights, the rights of transgender people, ought to be recognized like those of other citizens, and that the Zimbabwean constitution does not provide for their discrimination. And I like the part where the court then said it is delusional to think that we can wish away rights of transgender persons just because we might not understand, we might not agree with them, we might see them in a different light. And so it comes back to how courts have protected the rights of persons, of marginalized communities. In fact, most constitutions actually in the Bill of Rights actually use every person. And courts have noted that every person includes sexual minorities, persons living with disabilities, sex workers, refugees, and many, in fact, many constitutions, and I think South Africa's constitution is probably the only one in Africa, if I'm not mistaken, that expressly mentions sexual orientation as a prohibited grounds. Other constitutions don't. And we have seen this being used in other countries as a reason for why sexual minorities are discriminated against. However, courts have found a way to circumvent this. We've seen it in Botswana, Namibia, and Mauritius, where courts have noted that the term in itself, in its wider meaning, includes sexual orientation and gender identity. And courts have also relied on words such as social status or other status to protect the rights of LGBTI persons. So, and the advisory opinion of the African Court on Human and People's Rights also noted the scope of the right to non-discrimination in the context of the African Charter. And it noted that this right extends beyond the right to just equal treatment before the law, but has practical dimensions in that individuals should be able to enjoy their rights in the Charter without discrimination of any kind. It even went on to further state, which comes back to the previous point that I made, that the expression any other status encompasses those cases of discrimination which could not be foreseen during the adoption of the Charter. And so the right to equality, the right to dignity, and all other fundamental rights should not, and in a utopia, would not be violated on the basis of someone's status, expression, or socioeconomic standing. Now, it is important to say that just like most rights, the right to equality can be limited, but that has to be done so reasonably and in a manner that is necessary. And many courts have used the limitation analysis to sort of look at whether or not a limitation of a right is reasonable and is necessary in a democratic society. And with that being said, thank you for giving me your ears. Yeah, I'll pass it over to Arudi.
Oh, thank you very much, Tambo, for that precise presentation, as well as thank you for the resources that you've provided. And just, key things before I welcome myself for the next session. I think one of the key things that for me that I learn or I resonate with is the fact that the court or the justice system is one of the avenues that we can use to ensure that the rights of vulnerable and marginalized populations are realized within our different countries. As well, it's very, for me, it's always a good thing to hear around, cases that have been adjudicated and decisions that have come up that actually give more emphasis or more power to some of these human rights principles that govern us, this right to dignity, equality before the law and the likes. And therefore, it's also upon us as different national human rights institutions, as well as the civil society that are present within this webinar, to be able that as you're also journeying towards your strategic litigation or litigation as a whole within your country, that you as well give more power or more emphasis, or rather use the court's cases or the case law that has been already had within the Kenyan, not Kenyan, sorry, within the African region, to be able to give more emphasis to what you're pushing. Because there's always this, especially when it comes to LGBTIQ persons, there's always this perception of it being a Western notion and all that. And therefore, if we can be able to have, that judicial exchange and judicial dialogue amongst our different courts, for instance, for the Ugandan court to actually see that a court in Malawi gave a decision, a positive decision on this, and you quote that as you go towards your litigation, I think it also brings about some positive advancement, and it looks more African than it is Western. So thank you so much, Tambo. Just as a reminder, please, the question and answer as well as the chat sections are open for you to write your names, the institutions that you represent, as well as any other question that you may have. I know that there's a question that has already come, which I think I will try and deal with as I do my presentation. So I think I'll just have to welcome myself now that I'm the host. Okay, so yes, I'm going to take a few moments to, to deliberate, or we can exchange on the role of national human rights institutions, in advancing equality and non-discrimination in the context of, human rights as a whole. So how I'd organized my presentation is, first, I'm going to just give a brief pointers to some of the issues in general that vulnerable groups, that is persons living with HIV, persons who use drugs, LGBTIQ persons, sex workers, and any other that we might not explicitly name within this. So some of the issues that they face within the different African countries, one, of course, based on all the conversations that we've had earlier, is in terms of legal issues. Legal issues can come in different sectors. It can come with the exclusion of their issues within different policy, or it can come with criminalization of either their behavior, their expression within the law. The second one is poverty or economic status. You find, especially when you look at sex workers and sex workers, for instance, most of the reasons that push persons towards, that economic line of work is, either limited education or limited access to other opportunities. And therefore, the economic status of persons can really lead them to be considered as vulnerable and marginalized. And this also expands now the definition to also include asylum and refugee status that are as well represented within our various countries. Another key issue that persons face is in terms of arrests and detention. Because of, the vagueness in how the law is put, within our statutory documents, and as well as the discretion of the police to interpret the law as, as they wish sometimes, it leads to a lot of vulnerable and marginalized groups, usually facing a lot of arrests and unlawful detention within different detention centers. As well as access to services. We all know, due to the stigma, discrimination, misinformation, that keeps spreading across, that in a lot of times it hinders the accessibility, affordability of healthcare services and other services that include education, access to bank loans in terms of trans and intersex persons because of their legal documentation, for instance. We can't really neglect, issues of climate justice as well in this day and age, considering that, due to the climate change, there's a lot of persons that are being pushed away from their places that they used to live in, and therefore putting them in a peculiar position in terms of how they can be able to access some of these human rights. A big thing that has been happening across the world, and I'm sure everyone yesterday was, looking over this week, like really focusing on the USA election, amongst the many elections that we've had within the African continent, is an issue with regard to access to, or exercising of one's electoral power. In a lot of times, we find that vulnerable and marginalized groups, especially the transgender persons, intersex persons, and gender non-conforming persons, sometimes you find that the gender marker assigned to them at birth and how they present at this particular point is usually there's a disconnect. And in this, you find that it's very hard for them maybe to go and access, the registration or to go and freely exercise their duty to vote for their preferred candidate when it comes to election. And therefore, this is another issue that comes along. Lack of representation, within these institutions, in terms of people are not empowered enough, or there's still a lot of stigma that inhibits persons from occupying these electoral spaces or these spaces where decisions are being made. And therefore, it usually causes a default alienation of marginalized population in terms of their voice being heard. And that's why, as SDG says, we have to leave no one behind and nothing about us without us. And of course, funding across all, the lower you are on the Maslow's law, if I may call it so, sometimes how you access resources and remedies is usually a hindrance to realization of rights. And therefore, having that outlook on, the issues that are faced by the populations that we are talking about today, what is the role of national human rights institutions to that regard? And I believe that because I've seen within, the persons, the delegation that is here, there's a combination of both national human rights institution and civil society organizations. And so I just want to take 2 minutes to give an overview. So national human rights institutions are usually institutions that have been put out by the state in terms of the law or the constitutions, and they're independent bodies that actually have a very broad mandate of protecting and promoting human rights at the national level. Examples of this, as I look through, we have the Zambia Human Rights Commission, Malawi Human Rights Commission, Kenya National Commission on Human Rights, the Rwanda Human Rights Commission, and other commissions within depending on where you come from. So one of the key things is that it's important for especially civil society organizations to be familiar with what or the national human rights institution within their country, so that you can be able to utilize them in a bid to extend protection and to promote rights, especially of vulnerable and marginalized persons. So based on that, these national human rights institutions usually, as I said, they have a very broad mandate. And one of their key mandates is usually monitoring and reporting on human rights. So in this regard, because they're the the central point where human rights is monitored within their country, they have a big mandate of for instance, going to prisons and checking on, the status of persons who've been arrested. What is the situation of prisons there? What are the human rights plights facing maybe human rights defenders who are working on vulnerable groups? And with this power, they have a power to, write a report. And this report, depending on the different NHRIs, which based on the different articles or documentations that bring them up, can present this reports to Parliament or the executive. So just based on that, it's very important for civil society as well as national human rights institutions to ensure that when they are doing their annual reports to the Parliament or to the executive, depending on who you report to, or the Ministry of Justice in some instances, that you're able to, have a holistic outlook or a holistic input into as well vulnerable and marginalized populations. So how does this now intersect with civil society? Civil society organizations, sometimes are the first stop for a lot of these groups to go and report their issues. And therefore, it's important for civil society to as well create linkages with national human rights institutions so that you can be able either to give data when it's needed, or as well you can be able to ensure that your constituents or the beneficiaries that you work with are able to know that they can be able to access national human rights institutions and report their human rights. Another very key role of national human rights institutions in how they can come to protect vulnerable and marginalized groups as well is in terms of advising the government. Excuse me. So across the different jurisdictions based on the law, some national human rights institutions usually take up that role and advise states. And what do they advise them on? They can advise states on a policy that needs to be adopted for better realization of human rights within their country. They can advise states on a bill that has been proposed by maybe the Parliament or House of Representatives, depending on your country and how you call the institution that brings about laws. They can be able to look at that law and give their overview or their overview in respect to national and international human rights frameworks that have been put there. And a good example for this that I can speak of is, for instance, the Commission of Ghana. I know most of you know that a couple of years ago, there was this push for the family and proper human sexuality bill that was being proposed within the Ghana country. And the National Human Rights Institution there, that is the Commission on Human Rights and Administrative Justice, did a memorandum to show that the policy, if it's at all adopted as it is, it will be in violation of not just the Constitution, but some of the international and regional treaties that Ghana has ascended to. So this is also one of the ways, and which marries into my next point of national human rights institutions can be used as well to advocate for policy change. A key example when talking about vulnerable groups will be an example of the Kenya National Commission on Human Rights. So when you look at that, first, due to a case, there was a litigation case on the BBA case whereby an intersex child was born and the doctors didn't know where to place or which, sex marker to put on their birth certificate and all. And it led to this big case that eventually had a positive, decision, and the Kenya National was given one of the mandates to oversee a committee to implement some of the recommendations that had been put out. And with this, we've seen that there's been increase in terms of reform. For instance, the Child Act that was adopted in 2022 specifically has a protection for intersex persons. And there's a law that is currently being discussed within the Kenya National as well as other CSOs in terms of ensuring that there's an intersex bill or, an intersex law that will be adopted to protect all persons, because of course the Child Act, as even if it's had the explicit naming of intersex person, is only covering children. So what about the adults? So it's also another avenue that national human rights institutions can be able to work on. Another key thing is, simple things like statements. And I believe the Malawi Human Rights Commission chair also alluded to, participating in this pride events, giving out statements, educating the public on human rights as a whole, because that is one of the key mandates of national human rights institutions. And for instance, if there's a killing of a sex worker, there's a violation of rights for persons who are living with HIV, or all these marginalized groups, or asylum seekers, especially now that the law is usually being changed a lot to hinder, their full realization and their full integration within the society. The National Human Rights Institution has a mandate to, put out a public statement on that. And this can be done in collaboration with civil society organizations as well. That National Human Rights Institution have this very good thing called public inquiry. Public inquiry, in, if I can put it in the simplest of language, is they can do a research, or they can get feedback on a certain thematic areas across the nation or their jurisdiction. And this is a very good role and mandate of national human rights institutions, whereby CSOs can also see how they can well input into that, and how do they do this. So one of the key things that, of course, I'm sure all of you are trying and or are working towards is having that intersectionality that Commissioner Chikondi had referred it to as they were giving their presentation. So, that rights are not, you can't alienate and just say these rights only impact these persons. There's a way that, because we live in a society and all oppression is connected at the end of the day, we need to see a way of ensuring that when we want to speak on the rights of vulnerable people, for instance, if you're talking about prisons, you're able to integrate a lot of issues around prison. Is it the bond issue that is, hard for persons to get? Is it the rooming in terms of where is the placement during incarceration and things of the sort? So we need to ensure that in every human rights aspect that you're working on, there's the integration of vulnerable and marginalized groups. And for this, public inquiries are usually very good avenues to do that. For instance, you can do a research on sexual and reproductive health rights within your states or within your country. And with this, as a national human rights institution, you want to understand what is the status of sexual and reproductive health rights in this country. And with that, when you're talking about SRHR, you don't only talk about women or adolescent girls. You can also talk about, LGBTIQ persons and the access to those rights, and how the lack of accessibility can also impact. So that at the end of the day, we are trying not to alienate, but trying to show that everything is connected and interconnected. So that is also another avenue that civil society and as well as national human rights institutions can use in order to extend protection towards vulnerable groups. Another key thing, just feeding on to the discussions earlier, is this international human rights framework as well as the regional human rights framework. They always have these reports, that they are issued after every, for instance, the UN is around 4 years, and the African Commission has a specific, timeline, and there's a schedule to that. And with this, states are usually reporting on some of the advancements they've done to realize what they ratified within that treaty. And in this way, the National Human Rights Institution comes in and does an alternative or a shadow report to that, meaning they bring the truest picture of how the situation is, because as we all know, sometimes states love to pat themselves on the back, and yet, as we say in Kenya, the ground, when you go to the ground, it's a bit different. So in that way, we have seen that in some jurisdiction, the National Human Rights Institution has been able to form some sort of committee or some sort of stakeholder engagement with other civil society within their country. And in that way, they can be able to, the civil society can be able to bring more input into the alternative or shadow report that is being presented to this regional or international frameworks. And the best thing about that is because that is where some of these recommendations generally come from, where your state is asked, can you do something around discriminatory laws? Can you do something around the hate speech? Can you do something around the right to protest, the freedom of association, and things of the sort? So it's important for us as well to ensure that not only that National Human Rights Institution as an institution can be able to submit the alternative reports periodically according to the timelines that have been set, but as well as civil society organizations, we can be able to either input into the already draft that has been submitted, or we can form good collaborations with the National Human Rights Institution so that we are able to as well be involved in the drafting of that statement. And that is also another role that national human rights institutions can play into this. Investigation and complaint handling is usually also a key role of national human rights institution. For the civil society here, just know that almost close to everything that you envision to do as a civil society, mostly 90% of the time, of course, depending on the legal framework that formulated your national human rights institution, your national human rights institution can and be able to do that, or at least amplify your voice further. So there's no singularity when it comes to these matters. So investigating human rights violations, when kids are taken out of schools due to maybe their sexual orientation, or the fact that maybe the school cannot accommodate them or doesn't have awareness on this issue, or a hospital is is alienating sex workers or things of the sort. These some of the human rights violations that you actually face. National human rights institutions are given the power and the mandate to investigate this, not only at an individual point of view, whereby, let's say I am a victim of a violation, I go report directly, but as well look at the system and how that system, or whether it's the hospital, whether it's the prison, whether it's the school, has just investigate as a system, on a system basis. So they have those two levels. They can either investigate directly for an individual or the system as a whole, and this is also a good thing. And when it comes to investigation, all of us usually forget that investigation doesn't stop at giving a finding. Investigation actually stops, in my view, when persons either acquire justice and the victims have reparations for it. So it's important for us to also look at that dimension. And lastly, national human rights institutions, amongst other things, can be able to assist with strategic litigation. So this strategic litigation, or litigation as a whole, can either be for them directly asking for clarity, or towards the court, or as well can be as applying as amicus curiae or friends of the court, in terms of giving more substance to what can I, oh, the lawyer words are escaping me, you know, to their submissions that are going to be presented in court. So therefore, we've seen the South African Human Rights Commission use this very strategically in terms of things to do with hate crimes and hate speeches within South Africa. We've seen one of the groundbreaking cases. I'm pretty sure all of you have heard of Caster Semenya, who, you know, there was that issue with the IAAF, you know, the federation that runs this Olympics and things of the sort. And the South African Human Rights Commission joined the case within Europe, actually one of the first NHRI to do that, to argue in terms of discrimination and things of the sort. And as we look at the new geopolitical dynamic that is happening around the world, I know that there's a lot of unrest, especially for vulnerable and marginalized groups, not just LGBTIQ persons, but asylum seekers, refugee persons, sex workers. Because we don't know maybe the standing of our current leaders on some of these issues, or their opinions on these issues have already, you know, been put out there. And therefore, these are some of the ways that we can protect, you know, our human rights frameworks within our countries, within the African region, and as well as utilize the role of national human rights institutions in ensuring that our voices are amplified and that we can see more of, you know, the results of our work and our efforts. So in summary, that is basically some of the small avenues that national human rights institutions can be able to work with in terms of ensuring that marginalized and vulnerable persons within their respective countries are protected, yes, and their rights are realized. Thank you very, very much for your attention. Great. So it's a bit complex when you're the host and also yeah. So please don't get tired of my voice. So we've moved to, you know, one of the parts before we close this short webinar, whereby it's about reflection and the question and answer session. And yes, I would ask the delegates present within the webinar, you can either raise your hand. I'm sure there's a team behind that is monitoring that. You can either raise your hand and ask your question, or give your contribution or question within the chat box that is provided. So thank you very much. We welcome questions for the next few minutes before we continue. You can raise your hand or chat, do it in the chat. So we have one question from Henry Homsey, who asks, and I believe I'm going to direct this question to Commissioner Chikondi, though I've fairly touched on it, but how can national human rights institutions and stakeholders protect the rights of LGBTIQ persons and asylum seekers in Africa, ensuring non-discrimination, equality, and access to essential services amidst a rising anti-LGBTIQ laws? So, so far, that is the question that has been put out. So I think we can have Commissioner Chikondi try and assist. Thank you.
Thank you so much, Arudi and Henry, for that question. I think it's quite a very important question. In answering to that question, I must say that there is no magic wand as to how, but I think there are so many ways in how we can do that, depending on the context in which you are operating from. So like I said in the presentation, for like the Malawi Human Rights Commission, what we've been doing is to engage various institutions, stakeholders. I think the starting point would also be within the NHRI itself, where you actually understand the concepts, but also mainstream issues of LGBTIQ and other vulnerable groups in the work that you do. So for example, if you're working on, let's say, issues of elections, and you see how certain vulnerable groups are discriminated, maybe in the process of registration, voting, or any other electoral process that is happening, you also deliberately include LGBTIQ persons or sex workers or any other groups that you're working with. The same way if you're dealing with issues of hunger, issues of gender discrimination in different contexts. So it's all about being deliberate, not treating issues of LGBTIQ as the other or by the way, but making it part of the work that you do as a commission, even in terms of reporting as well. You make it deliberate when you do your annual reports on the human rights situation in your country, to report on how the progress that is being made from where the laws criminalize the lived experiences of LGBTIQ persons and the human rights impact of the criminalization, and also their experiences and the recommendations that as a commission you are able to make either to government or different stakeholders. I'll give you an example for Malawi. Like soon after the judgment that I mentioned that came out in this year, there were reported cases of increased violence against LGBTIQ persons, and the commission increased its engagement with the community, having periodic meetings with the community just to understand what is happening and keeping track and also investigating some of those cases. So you might also maybe need to be deliberate in some of the situations depending on what is happening. Like, for example, if an NHRI in Uganda looking at the law that was passed in Uganda or the proposed law reform that was happening in Kenya, you might have to be deliberate as an NHRI to look at that law and how it impacts on rights of LGBTIQ persons. Or if there's a debate on introduction of laws that you feel as an NHRI would impact on LGBTI persons, you can also be proactive and give your report and assessment of the dangers of enacting a law like that further criminalizes LGBTI persons or sex workers. Or even in terms of access of services. In Malawi, there have been reports of people that before the court judgment, they were able to access healthy services, but now healthy officers are not willing to provide those services. So your engagement now would be with how service providers are protecting and promoting rights of LGBTI persons. And then you may be deliberate to do an investigation on how these institutions are providing services. Are they discriminating? And then the report of the Human Rights Commission would be more credible in terms of the impact that it can have in dealing or trying to prevent the discrimination or the challenges that the LGBTIQ persons are facing in your country. But like I said, it depends on context, but these are just some of the examples that you can look at. Thank you, Arode.
All right. Thank you. I don't know whether Tambo has any addition with regard to the question. Now looking at the point of view of SALC and things as I get more questions.
I think Chikondi covered everything. To just add on the side of stakeholders, I think also we have also noted that sometimes it's important to have networks or connections with institutions, whether on the ground, whether institutions such as NANHRI and SALC, to also assist, especially in countries where it might be a security risk to put yourself out there, especially as an LGBTI person and as a refugee. And I think having those networks also sort of assists Yeah.
All right. Thank you. Thank you for that. And yes, it was a really good input because this is more or less a war, it's not a fight. So therefore you need to be prepared all around, and networks are very important. I have another question from the executive of the NHRI in Liberia, whereby they say even though LGBTIQ practice is outlawed by the penal code and the domestic relations law, providing punishment for sodomy and recognizing marriage between a man and woman. However, our Decent Work Act prohibits discrimination on the basis of gender identity and sexual minorities. That is actually really good. So with your experience in strategic litigation, so I guess this is open to Tambo and Commissioner Chikondi. So with your experience in strategic litigation, how can we as National Human Rights Institution elevate this provision to escalate our wider campaign against non-discrimination and specifically against the recent proposed legislation seeking tougher punishment for LGBTIQ persons? Keep your questions coming. We have a few minutes to the end of the webinar. So I don't know who wants to take, Tambo or Commissioner Chikondi.
I can come first, Rudy.
Thank you.
I think the starting point would be to understand the fact that there is no country in the world, maybe except with the registration from Uganda, that criminalizes LGBTIQ. Being gay, it's not criminalized. What is criminalized is the act itself, the sexual relationship between people of the same sex. The sexual act itself is what is criminalized. So that is the starting point to understand in terms of intervention in strategic litigation, because always there's a thin line where people think that LGBTIQ or being gay is criminalized. As such, any work or any case that goes to court that promotes or protects rights of LGBTIQ is seen in the light that people are seeking that same-sex relationships should be decriminalized. You can actually advocate for LGBTIQ rights without asking for decriminalization of same-sex. And that even goes to issues of, for example, recognition of right to freedom of association. You don't need to have the law changed on criminalization for people to enjoy the right to freedom of expression, or for people to have access to services. If they go to the hospital, for them to be treated equally before the law, or in terms of availability of services, they don't need to first of all challenge the offense, and then you can say, okay, after decriminalization, then I have the right. The right exists as we speak, and when we look at that in that manner, then it becomes easier in terms of building the jurisprudence around protection of LGBTIQ persons, because we always look at decriminalization as the ultimate goal, but what we believe is at SALC, and now speaking as a lead for the criminal justice program at SALC, is that you eat the elephant bit by bit. You don't put it all in your mouth at once. You will not be able to chew or swallow it. So you take the low-hanging fruits, and sometimes it's those ones where it's easy to sell before the court, to say, why should a person, because of their sexual orientation, not be able to access SHR services? You know, why should a person not be allowed to work because of their sexual orientation? It's not like when you go to ask or for an interview, they'll ask you, what is your sexual orientation? That doesn't matter. It's how are you able to perform of that job? So that applies to every individual, every human being. So if people are discriminated because of how they look, their perceived gender identity, that becomes an issue that can easily be pushed through the courts. And we've seen that in cases in countries where they have been able to get to the end of the road, which is decriminalization, they have started bits by bits. And you can also take lessons from that, like from Botswana. I think Botswana is the best example in terms of how they progressed in strategic litigation to come to decriminalization. And another issue to consider is also what I said earlier on is engagement. The rules in terms of strategic litigation, it doesn't matter on what issue you are dealing with, they are the same when you approach strategic litigation. So you understand the context, the timing, the court that you're in, and also looking at how you're going to enforce that. So understanding the context would be, is this the right time? Because you might have a good case, the right client, the right issues, but if you go to court at the wrong time, you may not be able to achieve what you want. Or you might have the good issues, but not the right clients. I think that was a good example, be the Malawian case where one of the people that had gone to court was being accused of taking advantage of young boys that he was supposed to be administering bursaries for education. So such kind of cases may not be great for the courts to look at those kind of facts, and then you are advocating for something more strategic or something that may be very controversial. So it's just balancing on the issues, the timing, but also dealing with the long-hanging fruits. Thank you, Alode.
Yes, Tambo.
This is why I like going after Chikwandi, because she says everything I wanted to say. I think my rhetorical question rather would be, how do you then leverage what's in the Decent Work Act? Like Chikwandi said, sometimes going straight for decriminalization or escalating issues might have a blowback. So how do we then leverage on the laws that are already there? If someone comes to you with an issue of employment, you are able to use then the specific act to say, hold on, but the law says you can't discriminate on someone based on sexual orientation or their gender identity. And it's building blocks. Again, like Chikwandi said, eating an elephant one bite at a time. And so I think, and I'm not familiar with the context in Liberia, but I think using the laws that are already there is just as important as challenging discriminatory laws.
Yes, thank you so much for that input, as well as just giving some more meat into the discussion. Is, I think, first, NHRI or the Independent Commission should take that up and give more LGBTIQ persons awareness of this law. And therefore, what will that do? It will give some sort of finding into, is this law being applied or is it not being applied? Because if LGBTIQ persons are not going to apply for these jobs, therefore you can't really know whether the law is strong enough to ensure their protection in terms of this decent work. So as well as just popularizing that and just using that to also show the good side of it. Has there been any wins due to this Decent Work Act that has positively impacted the community? And therefore, it also gives you leverage when you're asking or pushing for more laws, especially when it comes to the dichotomy or the thin line that is between states and economic development for thereafter, like having that direct linkages into how this Decent Work Act has led to increased economic value or standard of the persons that the prohibitions are named can also be a good avenue for that. So yes, thank you so much for our very abled panelists. Thank you so much, Commissioner Chair Chikondi, for that. Thank you so much, Tambo, the legal analyst from SALC, as well, for your input. And thank you for me as well, representing NANHRI. On to the last session whereby we're just going to have a few remarks from the deputy director of SALC, that is Tambo Nzai. So the floor is yours.
Thank you very much, Arudi. Just to say, I'm not going to say a lot. I think, you know, the speakers that have gone before me have really captured the most essential issues. And I am so happy at the fact that so many people have attended. This is such an important issue, and it's pretty clear that everyone here considers it as an important issue. Just to say that what we can pick up from the discussion as a starting point, you know, we talk about the protections in our constitutions and in our laws. And one of the most important issues is that where there are no specific protections for LGBTQ persons, sex workers, it doesn't mean the opposite, that where the law doesn't specifically say that, you know, LGBTQ people are protected from discrimination, it doesn't then mean that they are not protected. What it actually means is that they are human beings like everybody else, and all the rights that accrue to human beings in the state, in the country, in the region will accrue to people who identify in a certain way, have a certain sexual orientation, because everybody has a sexual orientation. We don't, as Chikwendi has indicated, we don't judge people based on their sexuality. And I think as a starting point for everyone, it makes it easier for you as a member of a human rights institution to know how to then respond when complaints come, in advising the state, in making recommendations. So I'll just say that what then comes out is that there's a huge spotlight that's on national human rights institutions. It's a big responsibility because they hold, I think it's sort of, you know, in law, we use words like sui generis. It's like a special position where you are a state entity of some sort, but at the same time, you are also an independent entity. So therefore, it gives you sort of a special position where you can stand in between. We all know that the traditional acrimony that comes between civic society and government. And I think the NHRIs have this very big bridging role there. And with collaboration with civic society in terms of mutual support, it becomes a very big avenue for upholding the rights of vulnerable and marginalized persons. And I think also in the context of criminalization, for example, it's you're sort of insulated from some of the issues that you know, civic society may face. For example, you have issues of, say, Nigeria and Uganda, where you have laws that try to criminalize association or advocacy for the rights of people that are criminalized. As a national human rights institution, you don't suffer from that same issue. Then that means that you can actually collaborate with civic society and be their voice or amplify their voice in appropriate circumstances. And I think that it's a big responsibility that I'm sure most of you who are part of these institutions have taken up. So I would like to then say, sort of, you know, give a challenge that we've heard so many things that could be done, including issuing statements. And from us at SALC, because litigation or strategic litigation is sort of our primary method of trying to ensure that rights are upheld, we haven't really heard quite a lot of NHRIs stepping in, providing amicus briefs and things like that. And my challenge is, can we do more of that? When we step in as civic society, at times we are considered to be partisan because that is what we advocate for, etc. But the NHRI provides a voice of authority for the courts, because that is really your role. Your role in terms of the constitution or legislation that establishes the organization actually says you are there to advise the state on human rights. So when there are court cases, that for me is the primary role that you can actually take up. I think also provide an authoritative voice that the court can quote without, being accused of having become too liberal or whatever. So that's a challenge. I'm hoping that as we go all forward, we will hear more, we will see more of NHRI stepping up. As SALC, we are always prepared to provide any technical assistance or advice or partnership, if that is the avenue that you have decided to take. And then my last point would be collaboration. I think amongst all the NHRIs, you've also realized that many different countries have different contexts, but there are situations where you can actually learn from the experiences and the activities of other people, how they have done certain things, how they have navigated, how they have even obtained funding, because I know that that's a very big issue, how they have managed to maintain their independence. So I think as another challenge, to continue to collaborate with other people. And then I would like to just then say thank you very much for coming and having this very important discussion with us, and sharing in the insights that have come up. I hope that we continue to talk, to continue to converse, to continue to learn from each other. I think we have gone a little bit over time, but I hope you forgive us. And then I'll give it back to Arudi to just dismiss us and end the meeting.
All right. Thank you so much for the closing remarks and the good pointers, to just bring, a summary to the discussions we've had. I want to give a special appreciation to each and every single person, or delegate as I call you, who has taken their time to be able to join us for this short but as well as meaningful conversation around the protection of vulnerable and marginalized persons within Africa. I appreciate your time. I appreciate the networks and sharing that has made this a success. I thank you, the team behind, who are ensuring people are in and all the communication is well aligned. And I thank you all, and I hope to see you again in another meeting or in another discussions, as we either celebrate some of the wins that may come of this, or tackling some of the challenges that may arise. So thank you so much. Do enjoy your lunch. Do enjoy your weekend. Please make sure to take care and to protect all persons that are around you. Cheers. We out.